અધિકારીની આપણે સમન્સ કરેલો પણ એ માધ્યની રજાઓ એવો મેસેજ છે.
गौतम पत्नी सचिन कुमार पत्नी તમે ગૌતમ એ કેસમાં તમારું નામ શું?
38
દીપક પત્ની નીચે છો.
રાજી
38
કદાચ રજૂ થઈ ગઈ.
નૈનાબેન 10 તારીખ 10 ડિસેમ્બર 66/1 સર આવી રીતે એ કોન્ફરન્સ સમજ કરેલો વકીલ બીડી પટેલ सेक्शन 114/22 जिग्नेश सांची
रिपोर्ट आपको जेल में अच्छे से पढ़ लीजिए राजस्थान चौबीस पे
सेक्शन 412/22 पिंटू दंताणी अक्षय दंताणी अक्षय दंताणी
આજે આપી દો. હા આ તો ના
મોહમ્મદ આવે ને એટલે હાજરી પૂરવાની હાજર છે. તો 152 કઈ તે ગુલામ શેખ Drum shape.
गुलाम शेख
25 बेड 152 बाई 23 25 बेड 8 नंबर ना आरोपी गाड़ी को वकील से आईडी पठान वकील से आईडी पठान
बाकी से आईडी पठान
बाकी
ये लो फोन करें
हां बाकी तो 25 बेड
25 पे 152 में
इसमें से 1003 बाई 23 देखा है वकील से आईडी कमाई
बाकी से आरती नंबर ये
देखा है 11 मार्च 11 करोड़ 10 22 बाई 23
11 करोड़ ಇದು 11
37 बाई 23 देखा है मार्च चिरागली शेख
हीरा लिखते है
समीर बानू महमूद भाई
जमीर बाबू महबूब भाई
43 बाई 23 मोइन खान
मोइन खान
दस 44 बाई 23 श्रवण बाई 24 अच्छा डी रजू भाई
कस्टडी में आते
तो आप दे 4 और सेंट्रल जेल हाँ श्रवण बाई 24 मनोज भाई सेशंस के श्रवण बाई 24 मनोज भाई
સાઈ વાહ પેટી પર લે આયા
આ સવારે હરદી ગઈ એમને 6:11 કોર્ટ રૂબરૂ મોકલજો
હાજી
रिक्वेस्ट है 7 again
7:11 सेंट्रल जेल 7:11 कोर्ट रूबरू
वेरी मच
હાજી
48 बाई 24 मयूर भाई आया सेंट्रल जेल मयूर भाई
બદલે દિવસની ભાષા
3 નંબર આયા છે રાજભાઈ હું 3 નંબરમાં હા
6:11
પ્લીઝ ઓબ્લેટ
कोटा 1 बाई 19 अब्दुल राशिद
અબ્દુલ રાશિદ
वकील श्री आईडी पठान
વકીલ આઈડી પઠાણ
मोहम्मद फारूक
મોહમ્મદ ફારૂક
मोहम्मद यासीन
મોહમ્મદ યાસીન
1:30 बाई 21 बदलू जामा
रिपोर्ट ऊपर कहीं जाता है बाकी तारीख आपको
4 का
राइट
एनआईए 50
ફર્સ્ટ ટાઈમ ટેમ્પરરી બેન્ડ એપ્લિકેશન ફાઇલ કરવી છે તો નેક્સ્ટ કોઈ પણ વીક આપને અનુકૂળ છે
तो स्पेस नेक्स्ट वीक तो
આપ સબને જેમ આમ
એને તારીખ લખેલી છે આમાં ક્યાં?
સર તારીખ નથી લખી છે બેલ એપ્લિકેશનનું ગ્રાઉન્ડ જ એવું છે કે એની ઇકોનોમિકલ સિચ્યુએશન ઇમ્પ્રૂવ કરવા માટે બેલ આઉટ કરો અને એની વાઇફ કે બીમાર છે એને ટ્રીટમેન્ટ કરાવી છે છોટી છે એવું એક ગ્રાઉન્ડ લખ્યું છે હા એટલે આ રીતનું ગ્રાઉન્ડ છે જે નોલેજમાં એટલા માટે ના
એમની અરજીમાં તારીખ લખાવી દેવાની તમારે જે તારીખ લખવી એ લખો પછી હું આપી દેવા
હા ભાવિક સાહેબના અનુકૂળ તારીખ છે.
હમ.
22/10.
22.
જી. Oblige.
And started to argue. And the court decided that let the matter be heard for exhibit 6 and 7. So court had ordered us to file a joint application, but my friend denied to file the joint application for the adjournment. So I filed an application requesting the honorable court to issue the frame or to frame the issues and adjourn the matter for further date. And then on matter was adjourned on 9th August 2024. At that time, I moved an application for the production of original document because there are so many documents, there are seems to be dubious. So I need to check because the adjudication is going to be done on that type of documents. And after 10 or 13 years, so important application was made, but there was no order from this honorable court. Then after, આ એપ્લિકેશન મેં કરી હતી,
કોણ આપી હતી?
તમે આમાં એન્ડોર્સ કરેલું જ છે.
ના ના કઈ કોર્ટમાં કેવા વાતો
પ્રજાપતિ સાહેબમાં જ
હા.
આપી છે. 9/8 આપી હતી સાહેબ. મેં no direction nothing, and on the same day in their reply, I come to their reply. They say that they have submitted some search report or some certificate. So I had written in my remark, if required, I shall file reply. This is the normal course. If anyone files, but they have made some allegations on me. They are ready to give the reply and they are pressurizing the court. I will come on their reply also, but
ના I don't have that much time. એટલે
અચ્છા.
5 મિનિટમાં sum up કરી નાખ. મને મારી પાસે already
Oh.
કોર્ટના remarks છે.
okay.
એટલે I am aware about the
Okay.
actual position which has been
So I
mentioned
leave it up.
in RNP.
Okay. So I will take 5 minutes, not more than that, on the basis of their reply.
Please.
Yes. So I come to the first paragraph. It is submitted that the present application is required to be rejected as the defendant and or his advocate have directly or indirectly made the allegation against two honorable judges of this honorable court and also directly or indirectly doubted the competency and administration of and case management system of your honor, the honorable judge, principal judge, City Civil Court, Ahmedabad. In this context, kindly see what I had. It was only a request letter. Unfortunately, this court was on leave. So I had moved before the additional principal judge who had converted this application into CMADC. I have only requested. I have never pressurized. And who am I to pressurize any court? This is merely an allegation on me as such. The advocate comes with clean hands before the honorable court. It doesn't mean that the advocate is pressurizing the court. So they have made the wrong allegation before me. And how the administration, in paragraph 2 also they reiterated the administration of case management has been disturbed by this application. It is not possible because the court looks, even I am trying to speak before the honorable court, there is some time. You can stop us. That is there. So we cannot, my argument is this, I can never and no one can pressurize the honorable court. So this is merely an allegation which amounts to the defamation as such. Then I come to paragraph, important paragraph, what they are speaking like. Kindly see paragraph 10 of their reply. With reference to para 9 of this application, the plaintiff specifically states, and while disclosing the defendant's application on dated so and so, thus are 24, the Honorable Court has fixed the date on 9/8/24 for hearing of Exhibit 6A1, notice of motion, and on the very same day, our advocate was ready to argue the hearing of notice of motion and submitted the documents which are most of in name of defendant, and the said documents are within the knowledge, and they rely on the said documents, even though to avoid the hearing of notice of motion, which is specifically fixed on very same day by this honorable court, as per request of learned advocate for the defendant, he has endorsed that he will file reply to the list of documents and seek play for time and thereby avoided the hearing of the notice of motion on the very same day. So here I say, on the same day, I had moved this application first. Then he came with this late documents, and I had just endorsed that I filed reply because court is not going to hear us. Honorable court has definitely, court has adjourned on the month of, after that 9th, it was adjourned on 8th
9th August.
October, 8th October. No, 8th October. On 9th, matter was adjourned to 8th October. So there was no hearing, no application, nothing for the adjournment was made by any of the parties. So this I conclude, and I request your honor, in the interest of justice, my intention to move this application only to get the justice, not to pressurize the honorable court. And as per, I rely on the direction of the honorable Supreme Court. Full judgment is also I have annexed with the application. So as per the direction of the Supreme Court, because this matter has been pending since 2013, it should be heard together. What is my request? I don't deny that Exhibit 6, it should be heard together. This time I'm saying, because I need the documents, and for that I moved the application for the production of original document under Order 13. So I request your honor to pass the order.
શું initial તમારા?
NN પ્રજાપતિ, NN with YJ Trivedi. પેલી છેલ્લી તારીખ કેટલી? 8-9 બધું.
તમારી સહી છે ને અંદર?
જી સર, જી. 9 ઓગસ્ટ. પ્લીઝ યોર, હું સાહેબ પાછળથી ચાલુ કરું કે એમણે કીધું the matter was listed before the Honorable Judge Sri P.I. Prajapati sir, and it was listed on 9th August 2024. The Honorable Court has specifically fixed the date for hearing of the notice of motion, even otherwise, and it was adjourned on 8th October. તરત બીજા મહિને જ રાખી હતી, ફિક્સ કરવા એને સાંભળી જ લઈએ. Even otherwise, the present advocate has filed this application. So this is required to the conduct of the advocates. He has not waited for the 1 month. સાહેબે કીધેલું છે કે હું સાંભળી લઉં છું, તમે આજે ને આજે મારું ઉતાવળ કરો, તમને ચલો વાંધી સાંભળી લઉં છું, તો પણ આ કરે છે. This is required to be conduct of the advocate. How he is pressurized this honorable court. Now, so far as my submission before, because the advocates are the part of the systems to assist the honorable court. We are not concerned with the name of the judge. We are concerned with the honorable court. So we have to fully support the honorable court to administer as proper administration and case management systems by the honorable court. So we have support the honorable court, not to pressurize the honorable court. And recently the honorable court is very well aware, because under the leadership of this honorable court and the leadership of the Supreme honorable court and then High Court, the pending suits are before this honorable court, and therefore naturally the all matters are allotted to the 1500, 3500 matters to each judges. See, in that circumstances, when the matter is pending for notice of motion, not the suit,
And in that circumstances, the pressurizing the honorable court that you first hear the shoot instead of the notice of motion is a conduct of this required to be considered. Now, so far as the Honorable Judge Sri G.L. Chovatia sir has at length passed the necessary order and within the knowledge of this honorable court, the required to be conduct of this advocate is required to be considered. Please, sir. Even otherwise, the judgment which was on which rely my learned friend is not support to the present case, facts of the present case. Because the present matter is since listed on board of both the judges for hearing the notice of motion, injunction application, exhibit 5. And knowing full well, he is instructing the honorable court to decide the first exhibit 1. So this is required to be one of the pressurized the honorable court. Now, so far as the next, the honorable judge Sri Prajapati sir is concerned, the very same day he has moved the application and he has moved the application before this honorable court that let file the frame the issues and matter may be fixed for hearing. The honorable court says, since matter is pending for NM hearing, why we are disturbing this honorable court? Honorable court has thoroughly hear him, and after hearing the anxiety of his other sides, the honorable court has fixed for the next month, next date for hearing. Even otherwise, he is moving before this honorable court. So my submission before this honorable court is that the judgment of the Supreme Court is not relevant where this matter is concerned, because if we go to the para 5, para 14 and 15, para 14, we make it clear that we are not making any observation on merits of the case. The learned single judge shall decide the suit without any being influenced by so. And 15, the Secretary General of this court is directed to send the copies of this judgment forthwith to the Registrar General of the Madras High Court, not the Gujarat High Court. So this is required to be considered because particularly Madras High Court is concerned, and therefore the Honorable Judge of the Honorable High Court has directed that the copy of the order to be placed before sent to the Registrar General and sent to the other courts. So it is not concerned with the Gujarat High Court or this Honorable Court. So in that circumstances, without reading the full judgment, pick up the one point of the judgment and on the circumstances, સાહેબ મારી સામે આ judgment છે, સુપ્રીમ કોર્ટનું તમે બંધન થશે, બંધન એમ ગભરાવાની કરવાની જરૂર નથી સાહેબ. એવી ધમકીઓ સાહેબોને આપવાની ના, હું નથી એમ કહું છું, એવી ધમકાવાની જરૂર નથી એટલે સમજ્યા. સો આપને વાત નથી, એ તો હું કહું છું, સાહેબ સમજી ગયા છે. So in that circumstance, I have given the detailed reply to all these. And the conduct of the advocate is to be considered by this honorable court. And this application is not filed by his client, but this advocate has filed this. And since the matter is pending for the hearing before the Honorable Judge Sri P.I. Prajapati, the matter may be decided by your honor court what to do. Rojnama itself is a record of the court. Please, highly obliged for patience.
28 લખાય તો નહીં તો પછી દિવાળી પછી
આપણે જ્યારે
આ બી અંદર છે.
meetings.